I have Justice Hamill. I've tried him out, I've heard him speak, he's fabulous. And it's a really important topic. Ties in very nicely with some of the themes we've been looking at prior to today and also today. And I've also asked Justice Hamill if he will say, as is the tradition for speakers in this course, just a little bit of how he got to this spot today, not including the car trip, but just professionally.
How do I make the PowerPoint work? That one? All right. Well, thank you for having me. And how I got to where I am today, I wasn't expecting that. So I did what was called then the SAB or BAB law course, which is now called the, I think, Legal Practitioners Admission Board course, a diploma course. I was working in the local courts as a clerk. I did that for about 5 years. Having got that qualification, I got a job as a solicitor at a shithouse law firm in Manly, which I really didn't like very much because my boss spent his days looking at the real estate section of the Sydney Morning Herald and asking me whether the money was in for the clients I was trying to represent in criminal court cases. So after that I got lucky in the sense that a friend of mine that I'd studied the SAB with was working with Justice Gaudron in the High Court, and she had instigated a system where she would have 2 associates who job shared basically and split the caseload to do the cases they were interested in. Before that, there was 1 associate, clever young law graduate, and usually a retired naval officer that helped the judge get dressed. Well, Mary Gaudron figured she could dress herself, and so she had 2, and 1 was going to university in America, so she got left early, and my name came up in dispatches, and I was lucky enough to fill that job with Mary Gaudron, and I think to a very large degree that was a significant piece of luck that got me to the bar as a barrister very young, because when I finished with Mary I was probably in my probably 23 or 24, and she encouraged me to go to the bar immediately rather than getting a job as a solicitor. And when a High Court judge tells you to do something, you tend to do it. And so I did it, and I had a career at the bar for about 25 years, predominantly in criminal law and towards the end in coronial law, so I was doing inquests. And then I got a phone call from the Chief Justice, and I hadn't really thought about doing this job, being a judge, and so I had a mild nervous breakdown and ultimately said not yet, hoping, I think, that he'd call me again, and indeed he did, or he got someone to call me so he didn't get knocked back twice, I think, but anyway. So I took the job, and that is 4 years and 2 days ago that I was sworn in. I say that because my staff who's sitting in the back of the court put on quite the show yesterday. They made me a cake with a little 4 and a candle, and then they made me watch The Bachelor last night as to celebrate. So anyway, that's how I am where I am, and is that satisfactory, Professor Hunter?
I think that's, yes.
All right, thank you. And I should say I had absolutely no family background in the law. My dad was a fitter and turner who worked at the Tempe Brickyards, which you might have seen if you're out on the Princess Highway, and then worked in a service station. So you don't need to come from any particular family, you sort of just have to work hard and have the occasional stroke of luck, I think. So thanks for having me here today. As Professor Hunter has said, we've attended a few common conferences over the last year or so, and we've seen each other speak. I've also quoted her jury studies more than once in my judgments, and she asked me last time we spoke together to come and speak to you, and I was delighted to do so. What I'm going to speak to you about today, and hopefully hear some of your opinions on it, and field questions if I can. At the end, if that'd be my preference, concerns the complex interaction between media and the law. It's a fairly hot topic, and I have seen massive changes in the 25 years or so, I guess it's 30, let's be honest, since I started practicing in the way the media covers the law and covers judges. Mostly, as I said, I was a criminal defence barrister, so I had some interest in watching the way my clients' cases were being presented. And over the last 5 to 10 years, I think the coverage by the media has become more brazen, more tendentious, more opinionated, and in both its coverage of criminal cases in particular, but also in its, reviews, if you like, of judges. So a couple of years ago, the person at the Supreme Court who allocates cases made the crazy decision to allocate a really, really big trial to me, which was a little unusual because I was a fairly baby judge, although I had some criminal experience. And as a consequence, I got to preside over what became known in the media as the Brothers for Life mega trial, and we've already had a sneak peek of Farhad, who was the leader of a criminal gang called the Brothers for Life at Blacktown. And we had 9 accused people charged with more than 50 offences. Farhad was unquestionably the leader, and they targeted another group and tried to kill them all over a period of about 2 or 3 weeks. And then there was a further offence, which I'll talk about at the moment. And in addition to Farhad, we also had a character who one of the barristers described in his closing address as being like a Lady Macbeth or Cersei Lannister figure, and she became known as Witness M. Regrettably enough, she didn't look very much like Cersei, but she was pretty entertaining in the witness box. So there were 6 different shooting incidents, there were 2 murders, and there were several attempted murders. They were very busy people over a short time, and they were absolutely hopeless. They were incompetent with one exception. They shot the wrong person. They murdered the wrong person because he was wearing a black cap, because Farhad had seen him earlier in the day and said he's wearing a black cap. So they went out, found a guy with a black cap and shot him. And they shot a 14-year-old girl who just happened to be at a house, and she's disabled in a way for life. And it was exasperating for poor old Farhad, and at some stage there was evidence that he said to the hapless crew, "How hard is it to shoot somebody?" And the trial created a media frenzy. There were many difficult things about controlling those proceedings. One was keeping the barristers somewhere on track, something I could relate to. One was dealing with a number of incidents of violence which broke out in the course of the trial within the dock. But unquestionably the most difficult thing from a legal point of view was balancing the rights of these accused men. They were all men once Cersei pleaded guilty and became a witness, against the rights of the public to know what's going on in our courts. And the right, therefore, of the media to report on what's going on in our courts. And so we had weekly or fortnightly fights between the media lawyers and the accused lawyers and the Crown about these issues. I was never a media lawyer as a barrister. I once got defamed by the Daily Telegraph, which was pretty good and somewhat profitable. But I didn't know very much about the law. But in the course of the Brothers for Life trial, a week didn't go by when there wasn't some application of some kind which would have the capacity to influence the case, and which brought into focus, in my mind anyway, the public's right to know balanced against the rights of an accused person to a fair trial. So we had application for non-publication orders to suppress the details of evidence, the details of witnesses. we had applications to close the courtroom, we had applications to revoke the order that I made yesterday, we had an application that the order I made yesterday was an affront to the public's right to know and the rights of the free press, and then the next day we had an application whereby it was said that the very lifting of that order was an affront to the accused's right to a fair trial. We had applications for witnesses to give evidence under false names and pseudonyms. We had applications for evidence to be given from remote locations, and there was even an application to suppress the gender of a witness who and his or her relatives. So towards the end of the trial, as we approached the verdicts, we had the media lining up to get access to all of the evidence so that they could go crazy at the end, as indeed they did. And so my staff were running up and down the city providing them with that material. So in the course of all of that, I think I might have gained just a little bit of expertise in the subject, and so far the Court of Criminal Appeal has overturned only 50% of my decisions in the area, a strike rate that I'm pretty happy about. By way of comparison, in bails I'm 0-4, although I have been vindicated in the High Court a couple of times, but not about my unfashionable views about the presumption of innocence and bail. In any event, the decision of the Court of Criminal Appeal, which was a pretty heavy bench, the Chief Justice, the President of the Court of Appeal and the Chief Judge at Common Law, is called Nationwide News and Kwame, and the reference is up there, and you'll see that the non-publication order that I made in respect of that first trial was upheld, whereas a takedown order I made, which I'll come back to talk about more specifically, was overturned. And the court, as I had done, had to grapple with this difficulty of people getting a fair trial in the days of mass media and social media and the increasingly brazen media coverage. So if I can just explain more about the factual landscape upon which these decisions were made. I mentioned the judge alone application at the bottom because it also grappled with similar issues. The accused were saying that they could not get a fair trial given the coverage that had been received to that point, and so in front of a jury. So they were asking for a judge alone trial. So those three judgments were actually all delivered on the same day. Excuse me. So I mentioned, I think there were 6 shootings. The first 5 shootings were related. That was the Brothers for Life at Blacktown, trying to knock off most of the critical members of the Brothers for Life at Bankstown. There was then a 6th shooting, which was unconnected, and it was basically a contract killing of a businessman called Joseph Antoon. And he was killed by one of the gang members, allegedly, and as I ultimately found, on the direction of Farhad. And so I had already ordered separation of those trials in that judgment there. So the question at the heart of all of these applications is a balancing of 2 great principles. As I've already said, if not implicitly then explicitly, that the brazen coverage of the media has become worse over the last 25 years, and I think in some instances outrageously so. But the courts, based on a very long common law history, and more recently based around specific legislation, has cherished the right and protected the rights of the free press, and the right of the press to be present and to report on court cases. And I have to say, from a political and philosophical point of view, I really believe that that is the correct approach and starting point. The freedom of the press is one of the cornerstones of a truly democratic society, as some very old cartoonist says, and as at the centre of informed debate. History shows us that the right of a free media is a crucial safeguard against tyranny, against capricious decision making, by both the executive government and indeed the judiciary. History is littered with examples of a free press providing a counterbalance to the excesses of government. You can look at any number of examples. Look at Watergate, look at the work of journalists exposing child sexual assault within the Catholic Church, something that was unheard of 20 years ago. Look at the conduct of the press in challenging Joseph McCarthy during the, if you like, communist witch hunts into anti-American activity. And you don't have to study that. You can watch an excellent George Clooney movie called Good Night and Good Luck. I recommend it to you. And the media also has an important role to play in educating the public about what goes on in our courts and the way the decisions are being made, and in criticising judges for mistakes. And judges make mistakes every day because they're just human beings going about doing the best they can. And that is a critical aspect of open justice. It's not comfortable when you're at the end of such criticism. I got criticised for a bail decision the other week by some bozo who was the, who was that fellow? The president of the police association. Cut the word bozo. Anyway, but it's not comfortable when you see someone railing against some decision you've made that day that you've made in good faith. But it's critical that it's allowed to happen. Without open justice, the system would simply descend into commissions behind closed doors, unrestrained quasi-judicial conduct and exercise of power. And it's that sort of thing that was emphasised in one of the seminal cases on the area, which was an English decision of Scott and Scott. The media lawyers basically have that one in their back pocket. But I really love the fact that our courts in this country are open almost entirely. Anybody at any time can walk into the back of the courtroom and sit down and watch what's going on. And that separates our system from most systems around the world. But it's obviously one thing to engage in informed debate and letting the public know what's going on. But it is an altogether different thing to descend into witch hunts, when the participants in legal proceedings are demonised, when the judiciary is demonised, when cases are presented in a salacious and unbalanced manner. Media personalities masquerading as journalists in complete ignorance of the facts of the case, provide their opinions and attack judges in the most extraordinary and sustained way. Inappropriate pressure is placed on the executive government, including the Attorney General, including the directors of public prosecutions, to intervene in cases which really otherwise wouldn't gain very much attention at all. And more particularly, the coverage of court cases can influence the outcome of criminal trials. When media present opinions as facts, these are some things that the so-called journalist John Laws said about one of my clients many years ago when he was on trial for murder. So Laws was so ignorant of the facts of the case that he didn't know that we were on trial for murder. He was reporting that we'd done a plea bargain, criticising the DPP for accepting a plea to manslaughter. That hadn't happened. We were in the middle of a murder trial with a jury of 12 people, and he called my client a scum and threw him in what he called the scumbag. It's very, very compelling stuff. So how does the court deal with that? Well, in the case of Mr. Connolly, the jury was discharged. It was Justice Simpson who brought this to my attention, and she had no problem in discharging the jury. And Mr. Laws was ultimately convicted of contempt. And one of the judges on appeal, the delightful, if somewhat fascist, Justice Marr, Roddy Marr, now deceased, so I think I can say that, said that he was fined about the same amount that he would spend on a small cocktail party. And Mr. Connolly, I should say, later when he received a fair trial, was acquitted of the murder and ultimately pleaded guilty and was convicted of manslaughter. But some journalists have found themselves locked up in jail. So one way that the law deals with this problem is through the law of contempt. But the contempt laws are reactive. The horse has already bolted. The trial's already been rendered unfair. And the damage has been done. And the contempt laws are also draconian. As I've said, journalists have ended up in jail, and nobody wants to send people to prison for exercising their right of free speech. No matter how poisonous or pig-headed or stupid or wrong the speaker's attitudes may be. Voltaire said, or at least he may have said or thought, I disagree with all the words you say, but will defend to the death your right to say them. So putting aside contempt, what can the law do proactively? And what it can do is cautiously to exercise a power to restrict publication of material for a limited amount of time generally. And the common law has long restricted the rights of judges to make non-publication orders to cases where it is truly considered to be necessary. That goes back to that case I mentioned of Scott and Scott in the House of Lords, but there are some pretty good judgments and writings from some New South Wales judges, and in particular, for those of you interested in the area, I recommend the works of Justice James Spiegelman, former Chief Justice, on open justice, both in academic sense and also in the case down the bottom. In that case down the bottom of John Fairfax and the District Court, His Honour really emphasised the fact that here what we're dealing with here is two great principles: the right of a fair trial and the right to open justice. And so the statute that now obtains in New South Wales is called the Court Suppression and Non-Publication Orders Act. And really it echoes what the common law has done and said for many years. It cherishes open justice and it restricts orders to what are necessary. So the centrepiece of the Act really is Section 6, which I'll allow you to read yourselves. And you'll see that the overriding principle is, sorry, I just did what the media lawyers did. I changed the indefinite article to a definite article. A primary objective, not the primary objective, but a primary objective is open justice. And the second critical part of the legislation is Section 8, and I've emphasised there that it's littered with the words necessary, and there are various things that might lead a court to make it. I know time is reasonably short, so I'll just leave you to read the Act for yourself, but there are a number of other important parts of the Act. And what they're mainly about is restricting the court's power to order non-publication. It limits the time and it limits the geographical location. And if you make an interim order, you can do so without hearing any arguments, but you must then hear the final argument urgently. So what does necessary mean? Well, I suppose the courts, as always, are reluctant to define what a word means, but are happy to tell you what it isn't. And so here we have, in the case of Hogan, what the High Court had to say. And that's a very important passage, because as a judge, trying to secure a fair trial, it is very tempting to do that which seems sensible, or that which serves the public interest, or to balance these rights. But the High Court and the Court of Appeal have stressed that's not how it works. So it's a very, very high test. And again, the media lawyers can actually recite that passage with their eyes closed. Let me see what I can cut out of this. Yeah? All right.
I've said that I'll make sure they were gone by 10.
Okay. Bachelor's not on again tonight, is it? All right, so I'll then won't rush so much. So one of the aspects of all of this is the whole body of authority, and this is where Professor Hunter's research is, in my mind, so important, and that is that there's a line of authorities where judges of the appellate courts, normally the Court of Appeal, Court of Criminal Appeal and the High Court, many of whom could only find their way to a trial court if given very, very clear instruction, have made it clear that the juries will obey the directions of the trial judge and can put out of their mind the impact of prejudicial media coverage. And there are any number of quotations to this effect. And obviously, as a trial judge, one is bound to follow that kind of reasoning. So there we have Justice McHugh in Gilbert. And there is a very fundamental assumption at the heart of the criminal justice and jury system that juries will follow the directions of the trial judge, that they are robust, that they may acquire prejudicial and irrelevant material in the course of their hearing a case, but we'll put that aside. And I think, Jill, you would agree that your studies would probably suggest that is generally correct, as a general proposition, that most jurors are, well, maybe it's that one I think you think might be correct, which is the following directions one. But in reality, the academic world has cast substantial doubt upon this line of authorities. And I'll just bring up a couple of the articles that I've found I've found very helpful in analysing this area in my judgments. And I think it's Bargarek at the top who delightfully said that line of authorities is nothing more than judicial wishful thinking. A line I've quoted more than once in my judgments. So, as I've said, you might want to read the study yourselves, but Professor Hunter's studies on jurors, real jurors, is that a frightening number take the view that it is okay to disregard the judge's instruction that they must not conduct their own research into the case they're hearing. At the beginning of every trial in New South Wales, we tell the jury not to Google, not to visit scenes, not to play amateur detectives, and yet, I'll come back to it, there are a number of cases where just that has happened. And Professor Hunter's study shows that there are people who actively think it's the right thing to do. It's not just a matter of they think they might be able to get away with it. They actively think it's the right thing to do. So as I've said, I've referred to those authorities. It comes up, sometimes I'm being asked to separate trials or to order a trial by judge alone, to make non-publication orders. And one side of the debate is saying, oh, you don't need to worry about the fact that the jury's going to hear all this poisonous material because you can tell them to ignore it and then everything will be okay. And so I have to deal with that submission, and I have to deal with it in an intellectually honest way because the High Court has told me that that submission is well-founded. On the other hand, there's a power to make a non-publication order. There's a power to sever counts from an indictment. There's a power to order a trial by judge alone. So those powers must exist for a reason. And then the reason is that there are limits to those statements by the High Court and Court of Appeal. So all of this is predicated on that proposition that the jury obeys directions, the jury's robust, the jury will disregard prejudicial information it may have heard about the case in the past or may go Googling for during the currency of the case. And of course that's a crime, by the way, under the Jury Act. A number of these cases led to reform, if it's reform, but changes in the law. And so the jury is, some judges take the view they shouldn't tell the jury this, and other judges take the view that they should. I take the view the jury should know that it's committing a criminal offence to go about Googling, using social media, going to the scene of the crime. I think they should know because it brings home just how serious it is. But so that's one thing we predicated on. The other is that what we're dealing with here is a fair and responsible press. So is that what we're actually dealing with though? Is that what actually happens? I'm going to ask you to forgive me if I tell you another Brothers for Life story. It did occupy 18 months of my life that I'll never get back, so I think you're going to have to indulge me. But during the course of that trial, there was a split. It was, in fact, it was in the course of the pre-trial, which went on for just the 3 or 4 months. And it became obvious that what at one stage was all for one and one for all, everyone was running the same defence, they're all solid, something had gone terribly wrong. And we think it was our favourite non-gender specific witness who may have been behind the change in dynamic in the dock. But in any way, one day I was about to walk onto the bench and my then associate or tip staff came out as I was about to walk on and said, "They're fighting." And I said, "Well, no, I think she came out and said, 'They're shouting.'" And I said, "Oh, well, I better come on then," because I thought they'd shut up. And then she came back and said, "Now they're fighting." I said, "Well, I'm definitely not going on, because if it's got to that, they're not going to care whether some dude in a red robe and a silly wig comes on and tells them to be good." So anyway, there was a fight. The dock was cleared. There was a search, and there was found in the dock a razor blade. So someone had managed to get through the marvellous security that Department of Corrective Services provide us with, a razor blade. And so late that Friday afternoon, a very fancy media lawyer in a beautiful suit came in late on a Friday, mind, to ask if I could make a limited lifting of what was in existence as a non-publication order. So it's typical, and the media is usually very responsible about this, that there be no publication of things that happen in the pre-trial hearing. So if I'm hearing stuff about what evidence should and shouldn't go in, the media doesn't report on that, because otherwise, well, what was the point? And so they came in late Friday, and the reason for the late Friday application was because they wanted a scoop. And they asked me if they could just lift the non-publication order to provide a story, an important story on court security. The Sunday Telegraph. Did I mention that? And so I was told it was just an article on court security that they'd been working on, and they said it would be an anodyne article. And I have my iPad on my bench, and I thought, well, I'm pretty sure I know what anodyne means, but I wasn't like 100% sure. So I quickly had a look, and I was greatly comforted because, as you see, it's dull, tedious, and run-of-the-mill. So that's what I agreed to allow them to publish. No names, no identification of the court, no identification of me or the barristers, and that's what we got. So it's pretty clever too, isn't it? Like using the razor blades to cross the A's. So the actual front page of the Sunday Telegraph was worse than that. It was similar but worse, but I seem to have mislaid it. Anyway, so that's what we're really dealing with when we're talking about open justice and fair and responsible reporting of court cases. We're talking about razor blade justice. Anyway, so I said earlier I'd talk about takedown orders, and in fact, Professor Hunter, when she invited me here, in fact asked me specifically to talk about takedown orders, but I thought an hour of that would be too boring, so I'll be fairly quick. What is a takedown order? So a takedown order is an order of the court requiring the publisher of material on the internet to remove the material, usually, but not always, for the purpose of ensuring a fair trial before a jury. There may be other circumstances where such an order is necessary. Something that came to mind in thinking about this was defamation proceedings. So if something's gone up on a website and is about to be published, there might, in the newspaper, there might be a call, but generally defamation cases are dealt with by injunction and in a different way. In a superior court of record, such as the Supreme Court, there's no question of the inherent power of a court to make such an order. In the courts below us, like the District Court, there is an implied power arising either from the Act creating the court, the District Court Act, the Local Court Act, or from the Court Suppression and Non-Publication Orders Act itself. In fact, I think it's probably correct to say it's not really an implied power because having something on the internet is an ongoing act of publication. So if you order non-publication, it has the effect of prohibiting that ongoing publication. So there's no doubt about the power to make such an order. The question is when and in what circumstances is it appropriate or necessary to make such an order. And what the cases show is that because of the nature of the internet and the way that it works, the occasions will be quite limited. There have been a number of cases in which single judges have made such orders. They're just a few. All of those orders were made by judges attempting to protect the integrity of a jury trial when there was material on the internet that could be accessed and which may have been misleading. That last case on the list should be treated with complete suspicion because even though the judge is a pretty nice guy, the reality is it was overturned on appeal. So we then come to cases of higher authority in which the Court of Appeal in Victoria and the New South Wales, I think Court of Appeal and Court of Criminal Appeal have considered this issue. And I think the first slide up here is from Justice Baston, in which His Honour simply confirms what I said before, that the publication of material on the internet is an ongoing act of publication, so that the Act applies. One of the things that was discussed in that case of Ibrahim was that the court ought not to make orders purporting to bind the world at large. again, Justice Baston made the point that if a person or corporation who has published the order and who is, published the material and who's maybe affected by the order is not nominated in the order and notified of the order, the order will plainly enough not be enforceable. And it can't be enforceable either as a contempt of court if the material is not taken down, or the other sanctions that apply under the Act. And His Honour, in coming to that conclusion, referred to this important passage from Justice McHugh in John Fairfax. This was when Justice McHugh was still on the New South Wales Court of Appeal. An order made in court is no doubt binding on the parties, the witnesses and other persons in the courtroom, but an order purporting to operate as a common rule and to bind people generally is an exercise of legislative and not judicial power. So we're talking here about some fairly fundamental concepts, the separation of powers and the three branches of government and on the limits of judicial power. But it's also important on a practical level, on a day-to-day basis, doing what I do, because generally speaking, lawyers who come to court asking for such orders haven't thought very much beyond the fact that there is poisonous and prejudicial material on the internet, on social media, and elsewhere, and they want it taken down, and they want the judge to tell them to take it down. But they haven't thought about who I'm going to tell to take it down. They haven't got the URL. And so it is my view that when such an application is made, the party seeking to make it is required to notify the person who's going to be affected by the order, that is the publisher. And then that person, as you may recall from many slides ago, then has a right to be heard on the application, one of the specific people nominated by the Act to have a right to be heard. So in the end, an order like that one, that all material published on the internet concerning the facts of the allegation against the accused and his or her extensive criminal record is to be removed. That's, as I say, not a thing. You can't do that. That is an order to the world, and it is not an enforceable order. So the order must be directed to a particular publisher or person, and it must nominate specific URL about which the complaint is made. The next issue is again a fundamental one, and it is again both jurisdictional and practical. Generally speaking, Australian courts cannot control what happens beyond our shores. Justice Baston again pointed out in Ibrahim that Australian courts cannot control the contents of servers based overseas. And this was one of the issues in the Brothers for Life case and those orders that I made that were ultimately overturned in the Court of Criminal Appeal. And this has to do with the very nature of the World Wide Web, the internet. Articles that are first published on an Australian news site just find themselves all over the world, published elsewhere very quickly. We realised that articles published on an Australian newspaper site was within hours, probably minutes, also on a New Zealand website, also on a Fijian website, also on a London-based website. So you can make as many orders as you like telling the Sydney Morning Herald to take down that thing off the Fairfax website. It's not going to make a scrap of difference, because all that would happen is that someone Googling Farhad Kwame and Cersei Lannister or whatever would just find the same articles published in the Fiji Times or one of the other newspapers that is republished because of their connections with the Australian media. And it's a bigger problem when it's an overseas or international site, but it's also a problem simply domestically because of the syndication of newspapers and the like throughout Australia. Again, as soon as the Daily Telly publishes something, it's published on 20, 30, I don't know, websites around Australia. I mean, I find the cases we're doing in country New South Wales are being published on the Gold Coast and in the Western Australia. No one, I suspect, much is interested in them, but it's just clickbait for the people who want to read the West Australian. And so, again, Channel 7's connection with that newspaper I just mentioned, the Western Australia, will mean if Channel 7 published something in Sydney, which might be of some interest to people in Sydney, it'll find its way onto the Western Australian website almost as a matter of course. And so one of the things we've been told that necessary does not mean is futile. To order Channel 7 in that example to take down the article would be a futile exercise if it's on the West Australian website. And I could ask them to take it down, or tell them to. But what if it's now on the Fiji Times? What if it's on The Guardian, published out of London? And so, again, you're going to think I've got a boy crush on Justice Baston, but in any event, I don't. And secondly, he does write the occasional good judgment. And in Ibrahim, he said some pretty interesting things. And if you read nothing else on this area of the way the internet operates, I'd probably recommend His Honour's judgment. And I'd also recommend, earlier, I'll give all these references to Jill in due course, but there's a case of Mockbell out of Victoria. There's a dissenting judgment in that case, which is worth a read as well, just on these fundamental principles of the way the internet operates and how it really just changes the paradigm that we're dealing with in terms of non-publication orders and the like. It's Justice Byrne, I see in my notes, who wrote the dissent in Mockbell. So the things I've been talking about in the last 5 minutes were the essence of my error in Kwame. What had happened was that the the Kwame lawyers had produced massive, well-prepared affidavits in which they had shown that there was a phenomenal amount of material on the internet and that it was poisonous stuff, and not all of it, well, in fact most of it probably wasn't accurate. It was just salacious and entirely prejudicial. But every time you took down this article, the next one moved up. And in fact, it got worse in one respect because the less reputable media organisations were further down the list. And so this is what the court had to say in paragraphs 89 and 90 about the orders that I made in that case. And it boiled down to the orders I made, well, it's very well intentioned, were futile. There was no point to them. It wasn't going to stop a juror minded to commit a criminal offence from finding the very same articles that they would have found had I not ordered 20 or 30 of them to be taken down. I think I'll give you that reference again from Mockbell. So I think what I've been saying really is similar to what I was about to say, which just concerns the number of articles. So we don't not only have syndication around Australia and articles published overseas about which we have absolutely no control, we also just have the multiplicity. I don't know if you can see it, but what I've just put up is a search that I did of old mate Farhad a few weeks ago, I think in preparation for the talk that I gave that resulted in Jill asking me to come here tonight. And what we see is there's 39,000 hits, relevant articles on Farhad Kwame found in half a second on Google. And I did the same exercise the other night preparing for tonight on Bing and DuckDuckGo. And yeah, on DuckDuckGo I just kept scrolling. They kept coming up. So I didn't read all those articles, but I'm pretty sure a lot of them would have had that image. on them. And the good thing about that image is that Farhad actually wrote to the publishers of the Daily Telegraph and the Sydney Morning Herald and asked them to stop showing that image because he felt that he didn't look all that innocent in that one. And indeed he also sent them a photograph of himself that he thought was a more appropriate representation of the inner Farhad. And this it must be true because the Daily Mail and the Daily Telegraph both published the story. And so he sent them that picture. Now that's not a man responsible for 6 shootings. Anyway. There's a class act. Anyway, so going back to the material that was tendered and relied upon on the application, it was deceptive. It certainly fooled me because as I read it, I thought, my God, these guys can't get a fair trial. And that's what meant that I would make these orders for the takedown of these articles. But of course what I didn't see or recognise really until the case was decided on appeal was that really it was an entirely futile exercise because of the very amount of material that was up there. So mostly I think these cases mean that it will be very rare for takedown orders to be made, but old friend Justice Baston did make the point in Ibrahim that there will still be occasions at paragraph 76 where they will be appropriate. One of the things that happens when one is being asked to make a takedown order is that the media, who's usually represented, as I say, by very fancy lawyers with very more limitless budgets, come along with very thick and scary affidavits in which they explain how impractical it is for you to ask us to do this and how technologically it's impossible and the world's going to stop spinning on its axis and it's just, no, don't even think about it, Judge, don't even think about it. So they say it's virtually impossible, impractical to do it, and they talk about caches and they talk about all sorts of technical things that most judges like me have no idea what they're talking about, and they're usually successful, although not necessarily in front of me. But in any event, they will tell you that. And yet, one day during the Brothers for Life trial, there was a witness who was protected. In other words, he was an informant. His name and identity was not to be published. And yet, the Daily Telegraph got hold of a tape of this person speaking and published it. They'd made a very vague attempt to, I don't know what the audio visual, what the audio equivalent of pixelated is, but they disguised his voice to a very minor degree. Witness turned up the next day. Mum and Dad had said, "We heard you on the radio. What the hell is going on? You're supposed to be protected. Your identity is suppressed." Life was in danger. And so I invited the Daily Telegraph and the journalist nominated in the article to come to court and tell me why they shouldn't be immediately referred for contempt. And by the time they got there, half an hour later, the thing was taken down off the internet. So it was possible after all. But as I say, we don't really want to lock journalists up for exercising their right to free speech. And I think, in fairness to the Telegraph, it was a genuine mistake. They'd made not a very great attempt to disguise the person. Where does that leave trial by jury? Well, at least some academics think that it leaves it in a bit of a bad way. And not only academics, but also some of my colleagues at the bar. A very close friend of mine ran a high-profile trial last year. He lost. Barristers don't take losing badly. But he says he genuinely believes that his client lost because of the publicity that the case had attracted in the time leading up to it. and couldn't believe that the jury had convicted. And he says, apply for a judge-alone trial every time there's such a high-profile case. So we get more and more of these applications to do trials by judge alone, and we give these clear and firm directions in which we tell the jury it's a criminal offence, and yet we see, not often, but often enough to be frightening, the actions of jurors like the one that Professor Hunter, or ones, who thought it was okay just to disregard those in a search for the truth. And you can see the motivation. They're thinking, I want justice. I don't want these lawyers to hoodwink me about what I can and can't know. It's just we just don't know whether what the Daily Telegraph or Daily Mail published 2 years ago, whether it has any bearing to what actually happened. And so there are, as I said earlier, a number of cases, any number of cases really, where jurors have visited the scene of crimes, have done Googling and so forth. And if you see the passage there from Justice Barr in the Wood trial, you'll see there's a lot of troubling aspects to that. One is the jury, members of the jury disobeyed directions, clear and plain directions. And two, when it was uncovered, they lied about it. So I don't think I got the passage where His Honour went on to say that he thought more than one of the jurors had lied. So this is a troubling time for jury trials, and it troubles me because I've spent 3 decades of my life as a firm believer in the right of an accused to a trial by jury. I rarely allowed my trial to opt for a judge-alone trial. It happened a few times. It was never to do with publicity, because I thought it was their best chance. If you lose one judge, you're gone. If you lose one jury, you've got 11 still there. And it does bring that common sense and real world into the courtroom. But it's terrifying to think, and I think it's partially the result of the kind of coverage criminal law gets these days, that jurors increasingly think it's okay to disregard the directions. So they're just a couple of examples. I think the Scaff case was probably the most notorious, where it's not just the accused, the victim in that trial, the victim of a shocking rape, had to relive the experience because jurors had gone out to the scene of the crime when they'd been told not to. So that's all I have for you, unless anyone has any comments or questions, or good reality TV shows they want to go home and watch. The man in the New York Yankees hat. I generally don't allow people in Yankees hats to attend my lectures. I'm a Boston Red Sox fan. Yeah. So it's a fashion piece worn out of ignorance rather than spite. Okay, that's all right. Sorry, who had a question?
I just wanted to ask, say for example with the Medically trial, obviously when impaneling the jury, did they have to confirm that none of the jurors had followed the first trial?
Well, yeah, look, there is a process that happens in every trial, and the higher profile the case, the more fastidious it is. I can't really speak to exactly what happened in the Medici trial. Did you guys go to that? No, I followed it, but didn't go to the empanelment. There's always a process in every case. So we're doing a trial down in Wollongong, which regrettably became a judge-alone trial this afternoon, but was a jury trial, and it had a bit of publicity in Wollongong. And we would have gone through a process of the prosecutor reading out the names of the witnesses, giving an overview of the case, and me making a speech about the need for them to be able to bring an impartial mind to bear. The fact that they followed it doesn't necessarily disqualify them. And there's a leap of faith that goes on. In the Brothers for Life trial, because it was probably a little bit like Medici in terms of the amount of coverage that was out there at the time of the shootings and leading up to the trial. We had, for one thing, an enormous jury pool. There were 300 people, I think, and we gave them a list of witnesses in advance. I think I invited them to come forward 5 times in 5 different ways over the space of 2 or 3 hours. Now, unlike what we see on American TV and what actually happens in some states in the United States, we don't have the ability to examine potential jurors as to whether or not they should be on the jury. But there is a process. But there is involved in that process a bit of a leap of faith, because you're asking the juror, do you think you can bring an impartial mind to bear? And most people are going to say yes, they could. Although again, the number of applications we had in Kwame suggests that people were, because they were all people who were there available to do a 6-month trial. They could have got out of being there much earlier, but they were there and they answered the question honestly and just came up and said, I don't think I can hear this case impartially. I don't know what process they went through in Medici, but it certainly would have been something like that. And I know they had a big panel.
And so then would say before the Lazarus, obviously the retrial of Philip Bolton was successful in getting a judge alone, would they have gone through a jury process first to determine whether there would be the availability of non-prejudicial juries?
No, probably not. So Lazarus was the King's Cross nightclub rape, yeah. And Philip, well, yeah, sure. I actually appeared for Mr. Lazarus at the committal hearing. So he got lucky that I got appointed to the bench because he got Phil Bolton instead, who's one of the best. And if ever you want to see a great trial advocate, go and watch Phil Bolton. If you want to go and see a great appellate advocate, go and watch Tim Game. But anyway, I think the answer is they would have formed the view that a judge-alone trial was necessary without going through the process and made the application. Whether it was based just on publicity, I'm not sure. Certainly that's what we were dealing with yesterday and today on the judge-alone application. And in Kwame, indeed, I was asked twice to do judge-alone trials and I refused the first one because, do you know the part of the Act that controls that? So Section 132 of the Criminal Procedure Act, 132? Yeah, 132 and 132A and 132 basically says, very wide test, interests of justice. So all your prejudice stuff can come in. But if it's a case that involves community standards, so reasonableness, indecency, those sorts of things, that doesn't prohibit you from doing a judge-alone trial, but it generally, judges won't order them in those cases. But they would have worked out earlier that they wanted a trial by judge alone because of the prejudice, I would think. Mm. Yes?
Just before you came, we were talking about the way in which the profile of juries has changed with the generations. If you think about, the sort of To Kill a Mockingbird type jury where their only source of information and news is really the newspaper that comes out that day. And Generation X or Generation Y. Do you think that the fact that we Google everything, absolutely everything, from like how to make something for dinner to how to put your makeup on, that's our strategy for life now. We look everything up. Like, do you think that that's likely to have a big impact on this whole business about trying to explain to juries that they can't sleep?
Absolutely, yes. I mean, that's the problem. I mean, do you remember, you probably remember things we used to have, it was on the tip of our tongue. Nothing's on the tip of our tongue anymore because we Google it. Yeah. We all do it. We do it every day. I mean, I think we did it 3 times sitting at the cafe nearby before we came here. And there's no question about it. It's very difficult to explain to people that to do that is wrong.
So do you think there's some way that we could make concessions to Googling things but say no site visits, or is there any way we could carve out some exceptions that would preserve people's confidence in jury trials but still maintain the you're not detectives thing?
Well, I have to say that I generally don't I don't purport at least to prohibit jurors from reading the newspaper or seeing things. You might see something about this case on the television, but you have to remember that you're the only 12 people who took the oath or the affirmation to try this case, and you will also see that the journalist who wrote that article has been in court for about 10 minutes, and you've been in court for 4.5 hours. And they're just doing a snippet. So I confront the reality that people will be exposed to it. But I'm not so sure about that. I think I can't see any relevant distinction between a juror Googling something than going on a site visit. In fact, I think it's perhaps more dangerous because it can be this kind of salacious, subjective reportage which could be completely inaccurate. Now, site visits, there are dangers if the site has changed. There's also a danger that the parties don't know what's going on. I'm not suggesting they're better, but I can't really see that saying, oh, it's okay to Google. I mean, if you Googled Farhad in the course of his trial, you wouldn't have acquitted him and read any of it. So I think you do, I mean, I think you have to prohibit jurors from making that sort of research, and then you have to take a leap of faith that they're doing it. And this is an uncomfortable thing, but you might also tell all of the jury that if you become aware that someone's breached any of these orders or directions about conduct, you should bring it to our attention. And that's how these things became uncovered. Not all of the jury went out to the scaff scene. I think 2 or 3 did, and then that was then reported to the judge afterwards, or the sheriff perhaps. I don't know there's an easy answer, but I can't see how saying it's okay to Google would actually work as if you then clicked, which you would, wouldn't you? Yeah. I think we always do. Yes, Yankees fan.
Yeah, I think Judge Peters overheard that application for a judge alone trial in Lazarus, and I felt that was from memory an issue with the jury, and they just wanted a judge alone trial. But just to add to the issues you sort of raised, you sort of mentioned when it comes to high-profile cases, we're going to start seeing a lot more applications for judge alone trial. My issue that I was sitting in a case recently that had to do with a sort of famous winemaking family in Australia, and you wouldn't necessarily, so obviously big family, big sort of brand, but when I think high profile, I think Medic, Pell, Scaff, but just even cases just that has some sort of hint of public interest, all of a sudden, as you sort of say, appears on Fairfax and News Corp, and then as you say, sort of trickles down. So how do you sort of distinguish what is a high profile case, and what's the outlook if we sort of get cases that just had a hint of public interest, all of a sudden they just blow up with all these articles you write?
Well, I mean, I think the question's very astute, and actually it feeds back into something I should have said in answer to your question, which is when you asked about the profile of jurors. I think this is much more insidious, if that's the right word, than jurors knowing about a particular court case. I think there has been an utter change in the way jurors start the process. And I think it is as a consequence of the general media coverage of the criminal law rather than as a result of the coverage of particular cases, although it's probably the combination of both of those things. So that it's always been the case as a criminal defence lawyer that you start from behind the 8 ball, but because you're charged with a terrible thing, in the first words the jury's hear, you stand charged that you did have sexual intercourse with X who was then under the age of 10. It's a bad start to any trial, no matter what you say in answer to that. I've never seen a person yet who looked not guilty when charged with child sexual assault, not one. And I think we'd all look guilty if we were put in the dock and charged with that. But I think that yes, that was always the case, but you could always fight back. I felt over my time as a barrister that the attitudes of juries hardened, particularly in Sydney. I used to think Sydney juries were great, which probably means I used to win. But I felt there was a hardening of attitudes, and I don't think is a coincidence that reflected the more, outlandish, tendentious, however you want to put it, law and order debate. I don't know if that quite answers your question, but I think it is more than high profile cases where there are issues.
And obviously, as you say, child abuse with that.
Yeah, well, yeah, nature of the allegations. Yeah. Yes?
I just had a question about takedown orders, where social media like Facebook and Twitter have grown to the point that we now post media articles and then maybe you copy and paste a chunk of the article and comment on it and then people start commenting on your post. Do you have power, and if you do a takedown order for that media article, do you have any power surrounding somebody posting that article and chunks of that article?
Yeah, I mean, I think the question of power is, yes.
I understand they're not media.
You've got to find out, like, so let's say you posted, let's put aside the link to the media article because that creates more problems, but let's just say you posted something on Facebook saying, I know that this guy who's on trial in the Downing Centre is guilty as sin. Yes, a judge could definitely order you to take that down, and that would not be a futile order necessarily because you can, there's this one, but once you've linked it, then it becomes this issue of the sort of media, the internet being impossible to control. So I mean, social media is a significant issue, and it's not one. Look, you know, the courts aren't equipped to deal with it.
You have problems with that?
I don't think dealt with it, but I can just see how it must be a problem. I mean, Twitter in particular, because that is where people are retweeting, and it does get to that point. Well, what's the point of making this order? There was a question up there. Someone had a question? Yeah.
Yeah, it was actually on that exact point. So was it Baston that said futile? Yeah.
A few of them have said it, but yeah.
I can definitely see the point there, but at the same time, if we're seeing media such as the Daily Telegraph continuously disobey orders, is there not still sort of just like a deterrent or like kind of name and shame element of like passing a takedown order and then having to take down that article at least off their own site and within their own ability? Just as sort of a deterrent measure. Like you said before, when you called in those reporters, like they already had taken it down. So sort of that, is there some kind of benefit or value there?
Well, I think that there is, and I wouldn't have minded inconveniencing the Daily Telegraph in making those takedown orders, but I don't think it would pass the test of necessity. That's the problem, and we're bound by what the statute said, and in my case, beyond the statute, the common law has always had that same test of necessity, so that I just don't know that the Court of Appeal, I could try it sometime, we could test it out, but I don't think if I said that I'm going to do this order as a result of deterrence, I'd get away with it any more than I got away with it in Kwame. But having said that, what Baston did go on to say in Ibrahim is that, contrary to what I might have given you the impression, it's not the death knell of these orders. If the Daily Telegraph published a particularly poisonous article and someone sees it on the net and they get to me quickly enough, that can be ordered to be taken down before it goes viral. So I think, and country cases are another example where you've got a tiny population who talk to one another and there's one newspaper. Again, I think targeted orders can work and can be quite effective, but yeah.
Last question.
I just wanted to ask your opinion on having non-publication orders in an open court. In particular, if this trial has gone on for several years. So my example, I'm just thinking of an example of when I attended. Professor Hunter will remember the Robert Z trial 2-3 years ago. It was his 6th or 7th one, and we had to attend for assignment. But the fact that it was non-publication but an open court and everyone already knew the story because it's been published in the media for so long, didn't that make the non-publication order pretty much pointless in that case? Because everyone already had an opinion based on what the media had published.
Well, so do you remember, was Justice Fullerton the judge?
Yeah.
Yeah, She's quite entertaining, wouldn't you say? Anyway, yeah, I mean, I didn't even know that there was a non-publication order in place during the currency of, what was it? Did you say the 6th trial?
I don't know. It was the last one before he was like they finally made a decision. But in that room, they were talking about a blood stain on a shoe.
Right.
Like it had gone into that degree. I think it was his last one before he was actually convicted.
Well, I suppose, let us say, I'm just making up a hypothetical, but let's say you're 10 weeks into the Z trial, the 6th trial, and the Crown comes up with a great bit of evidence that it hasn't bothered to show anybody before or hasn't found before, which happens remarkably often, and it's a blood on a shoe. And there's an argument before Justice Fullerton about the admissibility of that in the trial currently running before the jury, and Justice Fullerton says, I'm not letting you use it. Now, a non-publication order of that evidence would be an effective way to eliminate the possibility that the jury, who is outside, unaware of this argument going on, becoming aware of the bloodstained shoe. But I'm not sure if that's what happened. I'm not sure if that's the kind of thing that was happening. There's also non-publication orders in open court about particular things, like children, the names of children, always subject.
I think that Lee's just advised me that it was the niece in the Z case.
I wondered about that, yeah. So indeed, if you are dealing with a case involving a child, there's actually no need to make an order, and I don't make an order because the Children's Criminal Proceedings Act makes it an offence to publish the name of a child in particular circumstances, basically if they're a witness or an accused, etc. But I announce whenever there's anyone in the courtroom who's new that you can't publish this person's name because it's a crime under the statute. But I don't make a separate order. Some judges do, there's nothing wrong with it, but it seems to me unnecessary, and there's some case law that says you shouldn't do it. Yeah.
I just find it weird when you've already formed an opinion, like reading in the media, and then to just do it, because it wasn't just like, I know the niece was involved, but it wasn't just the niece, it was
No.
the entire family.
Yeah, I can't really imagine why there would have been a non-publication order more generally going on in the 6th Z trial.
There was, I think, sorry, just to interrupt, I think it was because of the sexual assault allegations that were part of that trial. Unless it wasn't open court, I think generally, I can speak for myself, even though I was trying way sometimes, there was nothing on the media about her uncle sexually assaulting her until after the trial concluded, and she came out publicly and spoke to the media herself, releasing a statement about those, what had occurred. So maybe it wasn't.
That could be right. And can I say one more thing just on the closing of open of court? One of the things I said in the Kwame judgment where I ordered non-publication, which was upheld by the Court of Criminal Appeal, I've only talked about the one where I went down, but the other one, which was like 90% of the judgment, was upheld. But just saying. But the sorry, I've lost my chain of thought because I'm gloating now. No, I'm sorry, I've just completely lost what I was going to say.
I've actually got something to help you remember
Oh,
later on tonight.
Yeah.
Thank you so much.
Thank
that was
you.
just fabulous.
Thank you.